Post-sale confusion. Confusion that arises after the point of sale and experienced by individuals other than the purchasers of the product. And why is that a potential concern of trademark law? Certainly a matter of debate in the literature. And so the case I had you read is Hermes International versus Letterer de Paris, Fifth Avenue Incorporated. And here we have a suit against the maker of replica high fashion bags. And there's a defense based on laches, and the district court buys it, but the appellate court says, sorry, you can't bring this kind of equitable defense where you intend to engage in infringement. So we see our old friend here, the idea of bad intent on the part of the defendant as being a reason to rule in favor of the plaintiff, even in a situation where we at the very least have a very debatable argument about whether or not there's any confusion worth policing at all, and where it's debatable that the defendant is doing anything wrong. And here we have an interesting debate about not so much the intent of the parties, but rather the intent of the customers of the relative parties. But let's back up and get to the court's rationale for why we have bad intent on the part of the defendant. And so what does the court say? It is clear that the appellees intentionally copied Hermes's designs and sought to sell knockoffs of the originals. They thus intentionally traded off of the Hermes name and protected products, and should not have been entitled to invoke the doctrine of laches as a defense against Hermes's claims for injunctive relief. And so what's the actual confusion and harm here? And so here we are in the post-sale box. And so what are the dangers? The sale of knockoffs may cause fear in the market for the original. And so is that necessarily confusion? Here we don't have any actual allegation of mislabeling in that market. And so the buyers here are not in fact confused. And so they don't suffer from that fear. Next. Deception in the resale market might follow, and there might be a need for expertise to distinguish between bags in the resale market. And so here I think there may be a consumer harm story to be told, insofar as we want consumers to be able to purchase goods on the secondary market. And so the possibility that there's knowledge that there's a lot of knockoffs out there, maybe that makes things a little bit harder on the secondary market. But again, here we are not dealing with a secondary market case. And at the very least, that would seem to transmute this not into a direct infringement claim, but rather into a secondary liability sort of claim. This idea that it's not the defendants who are deceiving people, but rather people may use defendants' products to deceive others in the secondary market. And then we can get into questions about what the defendant knows and whether they have the requisite knowledge to put them on the hook on a secondary liability theory. And of course, we'll cover secondary liability in future lectures. Then we get to one that I think is kind of controversial and, probably the one that matters the most for the court. Maybe it's the one that is best keeping in the intuitions of those who think that the defendants are engaging in bad conduct here. Finally, the purchaser of an original is harmed by the widespread existence of knockoffs because the high value of originals, which derives in part from their scarcity, is lessened. And so query whether this is the kind of thing that is a trademark harm, or alternatively, is the kind of harm that trademark law is designed to address. Now, another argument that gets floated in favor of post-sale confusion is this idea of third-party perception, that maybe someone will perceive a cheap knockoff and blame the mark holder. But of course, people should know that there are knockoffs out there, and sometimes things get used and, they fall into disrepair. Query whether that's a non-speculative harm that actually is experienced by trademark holders. But that's another rationale you'll see in post-sale confusion cases now and then. But let's talk about this question of lessening the scarcity of a luxury brand. This idea that the thing that's really wrong here is that some consumers are out there purchasing expensive style on the cheap. And so this idea that knockoffs may lessen the cachet of luxury items. And again, whether that's a trademark concern. And so, to my mind, and your mileage may vary, is that it seems like the court, is observing that there are snobs and there are poseurs. Some people just want to be able to benefit by having the exclusive brand, and some people like to pretend that they are able to afford the exclusive brand, but they do it on the cheap. And, to my mind, a lot of what's going on in post-sale confusion cases is the favoring of snobs at the expense of posers. And I think there's a really open question about whether or not we should. I mean, again, to disclose my biases, I don't see why status competition is the concern of trademark law. There's a very strong intuition here that there's some kind of free riding going on here, and we can logic it out as to whether or not that's a meaningful claim, but there's a very strong human intuition at work, shared by judges, shared by juries, and so it's not surprising that trademark law is going to reflect that. The question, though, and the one that I'm always interested in these situations, is that, okay, maybe we have a democratic argument for allowing these kinds of claims to exist, insofar as that's what people seem to want. However, once you start using the tools of trademark law to vindicate claims that are at odds with certain basic trademark purposes, there's this possibility of spillover into other kinds of settings. And so let's talk about the Georgia-Pacific cases. And the Georgia-Pacific cases are not about status goods. They are not about luxury handbags. They are not about Rolex watches. They're not about Armani suits or Lamborghini cars. They're about paper towels dispensed by machines in hotel bathrooms, airport bathrooms, and the like. And so the background to these cases is that Georgia-Pacific makes a touchless paper towel dispenser, and they make compatible toweling for these dispensers. And once they lease these dispensers out with the Georgia-Pacific label, they want their clients to sell Georgia-Pacific toweling because they want to maintain this relationship. They don't want them looking outside of Georgia-Pacific to somebody else's different off-brand paper towels. However, people are people, and some users of the Georgia-Pacific dispensers are contracting with other parties to supply the paper towels for the Georgia-Pacific dispensers. And so here we have litigation against one of those competitors with Georgia-Pacific who provides a compatible, cheaper, and in Georgia-Pacific's eyes, purportedly inferior brand of toweling. And this competitor is sued for contributory trademark infringement. And the Fourth Circuit buys that there's a trademark claim here. And they allow the claim to proceed, and Georgia-Pacific winds up winning a over $500,000 judgment in its favor. And so what's the rationale of the Fourth Circuit in letting this claim go forward? They say that a toweling dispenser, it's kind of like a soda machine that's dispensing Coke, and people are going to assume that the dispenser is going to only dispense toweling of that sort. Now, that's actually not accurate as to Georgia-Pacific. They actually make universal dispensers as well that sell toweling or dispense toweling from other makers, but that's life. But here's the real problem with this, is that who is the relevant purchaser class here? Who is buying the toweling for these machines? It is not the people who are going into the hotel bathrooms. It is not the people going into the airport bathrooms. Who knows what they actually think, right? I mean, if you're not thinking about it, and this is where we get into questions of materiality or consumer attention. If you're not thinking about it, you may just assume that the machine says Georgia-Pacific on it, and so maybe it's a Georgia-Pacific towel coming out of it. But that's probably, you're probably not thinking about anything to do with the machine. You just, use the bathroom, you just wash your hands, and you're off to catch your flight. You're off to get back to your hotel, your room, to get back to your conference, to whatever. Okay, so one thing that you are not doing, though, is that you are not going to be buying paper toweling for an institutional account unless you're in that particular business, unless you work for something like an airport or a hotel or a restaurant or that sort of thing. But if you are in that kind of business, then you happen to know that it is not, in fact, the case that all paper towel dispensers only use or dispense the paper towels of the maker of the dispenser. Indeed, if you're buying from someone other than Georgia Pacific, you know that it's not Georgia Pacific that is selling you the paper toweling. And so this idea that there's some potential harm to Georgia Pacific's reputation when someone goes to an airport bathroom and, hypothetically has a bad experience with a paper towel that comes out of the machine, or it jams or whatever, that this theory of, shoddy paper toweling is actually correct. The line that gets traced to actually have that result in a harm to Georgia Pacific just doesn't track effectively. And to my mind, I think that this case shows that we have this real problem with a post-sale theory, because we have these precedents about post-sale confusion that says that people other than the purchasers, their confusion may matter. We open the door to considering the potential confusion of people who are completely irrelevant, people who cannot cause any harm to the reputation or bottom line of the trademark holder. And it highlights certain gaps that we have in trademark law. The absence of a materiality requirement, the consideration of irrelevant confusion, right? These vague appeals to reputation control without a clear explanation about how they might actually be meaningful in practice. The utter lack of concern of harm to non-confused consumers. Because note, if Georgia Pacific gets its way and enjoys market dominance in the sale of paper toweling, these costs are ultimately borne by consumers. Insofar as, say you're dealing with a hotel, the hotel now has higher costs for paper toweling. Those costs have to be compensated for somewhere. That's going to be recovered in the rates charged to the clients of the hotels or other institutional entities. We also see the problem that we've talked about before of the potential circumvention of relevant factors in the multi-factor test that would provide context in favor of a defendant, right? Things like consumer sophistication has to be thrown out the window if we're not going to consider who the actual relevant purchasing class is, marketing channels, and that kind of thing. And in the actual litigation, there's this welcoming of surveys that, sort of show this expectation of some kind of association between towels and dispensers. But of course, who cares? The people who actually make the purchases don't have that association. And if they did, then we might have a different kind of claim on the merits. Now, it's worth noting that Georgia Pacific wasn't successful at the full nationwide level with its campaign, but it did win again. A nearly $1 million judgment in the Fourth Circuit. They lost in the Eighth Circuit. They lost at trial, and that trial judgment was affirmed. And in that particular opinion, if you look at it, there's still no general consideration of the needs or interests of non-confused consumers. There's just sort of this nod to industry norms to find that there's no bad faith and to discount the survey evidence that was, probative in Georgia Pacific's favor in the Fourth Circuit. And so the upshot of all this is that, the effect of post-sale confusion precedents can radiate outside of the sphere of luxury goods where they're normally discussed and debated. And so even though Georgia Pacific gets mixed results at trial, the theory retains its interim effect and allows Georgia Pacific to potentially distort the market in which it operates. There's no real easy screen to the expense of a trial. So recall the concern the Supreme Court had in the Walmart case, that that we want there to be some easy way of dispensing with suits that are targeting competition at a fairly early stage without requiring the defendant to expend all the expense that comes with discovery and potentially with an actual trial. And we see a lack of sensitivity to that concern in a lot of these cases that deal with the possibility of confusion in situations not involving source confusion at the point of sale.